morning and welcome to today's segment of Immigration Insights. My name is Yamilet Medina. I'm an attorney with the law offices of Carlos Cruz, and we have Mr. Carlos Cruz present with us today. Good morning, Mr. Cruz.
Good morning, Yamilet. How are you doing this morning?
I'm doing well. How are you?
Well, thank you for asking.
Well, thank you for being with us this morning. Today, we have a couple of topics to talk about. The first is President Joe Biden's announcement that he made regarding a pathway to citizenship for spouses of U.S. citizens. If you could please give us an overview of that announcement and what that means.
Certainly. So first of all, on behalf of my office, and I think the entire immigrant community, I think it's important to thank President Biden for what he's done. I think it is essential to continue to look for ways to help immigrants trying to legalize their status in the United States. Having said all of that, I think the program does have some significant limitations that we have to address. But before addressing the limitations, let's talk about the basic requirements. And there are two primary requirements based on this executive order. First, the person has to prove that as of June 17th, 2024, that individual was married to a U.S. citizen, not a legal resident, but a U.S. citizen. And then second, that individual has been in the U.S. continuously for the last 10 years, again, ending on June 17th, 2024. If you satisfy these two requirements, then you can apply for something called parole in place. Parole in place is a document that allows you to request your interview for legal residence inside the U.S. in order to avoid going to your home country for the interview. Parole in place. What's important here to understand is that parole in place does not mean that you automatically get your lawful permanent resident card. It does not mean that. All parole in place means, if granted to you, is that you are allowed to request the interview for legal residence inside the U.S. In other words, rather than having to leave the U.S. and going back to your country for the interview, whether it's Mexico, El Salvador, Colombia, or anywhere else in the world, you're going to be given that interview inside the United States. But having the interview inside the United States does not mean an automatic green card. It means that the United States is going to decide, immigration is going to decide in the U.S. whether you are eligible or not eligible for that legal residence. The word that we use, as you know, Yamilet, is whether you are inadmissible or not inadmissible to the United States. So when we look at someone's eligibility for legal residence, yes, the first issue is, can we have the interview in the U.S. or is the person required to leave the U.S.? Step one. But step two, once we file, or if we're going to file that application for legal residence, is this person inadmissible? The question becomes, what makes someone inadmissible? Well, there is a laundry list of reasons that may make you inadmissible to the United States. And that goes from criminal convictions, even arrests, prior immigration violations, like deportation orders, removal orders, multiple illegal entries into the United States, fraud. There are many reasons that we consider in assessing whether or not someone is eligible. So I think what's most important here is this. Number one, we need to make sure that the program goes into effect. This program has not gotten into effect yet. And we have to remember that this program, this executive order, is very likely going to be challenged in federal court, and that a federal court judge could stay the program and stop the program from going into effect. That's problem number one. But problem number two, I think, is this. Do not assume that just because you're married to a citizen and you've been here for 10 years, that you automatically qualify for legal residence. That's not what this means. What this means is that if you do satisfy these two requirements, that you need to speak to a lawyer to decide and determine whether or not you meet the criteria for lawful permanent residence, given this laundry list that could potentially make you inadmissible to the United States.
Well, thank you for that overview. You mentioned multiple entries being something that you look out for. So is it possible to apply for the parole in place, get that granted, and then not be able to move forward with the process here in the U.S.?
That's a great question. The answer, my answer would be yes. Parole in place is a discretionary grant of a work permit in essence, because once you have this parole in place under the President Biden plan, they're going to issue you a work permit. So we have cases now under the same program called Parole in Place for the spouses, for example, of military members. So, for example, Yamilet, if your spouse was in the military and was honorably discharged, or still in the military, that document, parole in place, already exists. Parole in place is already available for the spouses of military members. So all that President Biden did was extend that document, parole in place, to now the spouses of U.S. citizens who have been here in the country for 10 years. So with those parole in places for military spouses or a spouse of military members, yes, there have been cases where the service is aware that the individual has left the United States and returned to the country illegally for a second or a third time. And in their discretion, they have granted the parole in place to at least issue that person employment authorization. Now, for military cases, that employment authorization is only for 1 year. Under President Biden's plan, the work permit is going to be issued for 3 years. So there may be a set of cases where individuals may qualify for that employment authorization card for 3 years, qualify for a Social Security number card that accompanies the work permit, but may not qualify for lawful permanent residence. But that needs to be looked at on a case-by-case basis. Now, some may say that if you don't qualify for legal residence, you may not qualify for parole in place. That's true. The administration could take that point of view. That what's the point of giving you that work permit and that parole in place if you're not going to ultimately qualify for lawful permanent residence? That is up to the administration. All that I can tell you is that when it comes to parole in place, based on military service, that parole in place, that work permit has been issued to individuals, even though CIS knows that the individual is not going to later qualify for legal residence.
Thank you for that. Now, what does this program mean for, waivers, things that people will say, do I need a waiver before applying for this program? Is that something that still applies here?
Sure. So having the interview in the U.S. allows you to apply for certain waivers. So let's say, for example, that you have a prior violation for committing fraud along the border. You presented a false document, a false legal resident card, and you had the very good fortune of not being ordered removed by the officer at the border. That officer, in his discretion or her discretion, granted you voluntary return. But there's a fraud listed in your file, which comes up, obviously, in your FOIA. You can apply for a waiver for that ground of inadmissibility, that fraud, at your interview if your parole in place is granted. But I think there's something bigger here that I think we need to address. And that is, let's assume that President Biden's plan is stayed by the federal courts, that the plan does not take effect. The question is that the end of the process or that application for the spouse of a U.S. citizen? And the answer is no. And the reason is this, in my legal opinion, if you qualify for that parole in place under Joe Biden, under President Biden's plan, it is very, very, very likely that you also qualify for something called an I-601 waiver for your unlawful presence that allows you to leave the U.S. to pick up your legal residence in your home country and return within usually 2 weeks. 2 weeks. So most of our clients who have to leave the country to, in essence, pick up their legal residence, come back in less than 2 weeks. Most of them within 10 days of their interview out in their native country. And so it's important to understand that if the plan is staying, if the plan does not go into effect, you need to really have a consultation with the lawyer about whether or not you qualify for that unlawful presence waiver in the U.S. that allows you to go to the interview in your country, which then allows you to return to the U.S. in about, usually, again, 7 to 10 days, less than 2 weeks. I know many people are afraid to go to their countries because they hear about all these horror stories about people getting stuck outside of the U.S., not being able to return to care for their kids, not being able to return to care for their elderly parents. And I can't deny it. It does happen. That does happen. But it usually happens, Yamilet, when the person is not well represented, when the person lacks the adequate legal representation that they need from the beginning of the case, not at the end of the case, at the beginning of the case, to decide whether or not they're eligible and to decide whether or not to file that application. When we look at a case in my office, I look at the worst possible case scenario. I ask myself, if we get the worst immigration officer, the most strict individual looking at this case, what reason is he or she going to use to deny this case at the interview at this individual's foreign country? If the answer to myself is there is no reason here, then I strongly recommend that person to move forward with their case. If there is a reason which may result in the denial of the case, I tell that client from the very beginning, sir, ma'am, If you leave the country, there could be an issue here. For example, because you brought your child when he was a minor illegally. You brought that kid here illegally, and you could be barred from admission, which may mean to you waiting in your country until you are forgiven for bringing your child here to the United States. You need to be aware of that. And if you are barred based on that illegal entry of your child, to which you contributed in some way, then you're going to be stuck. That's the word. You're going to be stuck in your country for a few years until you are forgiven for that. Is that forgivable? Yes, it's forgivable, but there's no guarantee, of course, that you're going to be forgiven. So the person from my office is going to know going into that situation that, okay, I'm going to apply for this forgiveness based on my unlawful presence before I leave the country. But I know full well that I brought my kid here illegal. I can't deny that. And if that is used against me because I was involved in some way and I'm accused of what we call alien smuggling of your own children into the U.S., I am prepared to await for a decision on that second waiver application in my native country. Now, some parents will say, I'm willing to take that risk. I'm willing to wait outside of the country to be forgiven for that illegal entry. Others are going to say, there's no way that I'm going to leave the country if there's a minutia of a chance that I'm going to be stuck waiting for forgiveness or something like that. At that case, you don't move forward. You tell the client, then you cannot move forward with your case because that is a real risk. I'll give you another example. Let's say that before you came here illegally to this country, you went and requested a visa and unfortunately used fraudulent documents. You get false information. It's very likely that that information is going to come up in the interview at the U.S. consulate. And so you need to know that if in fact you committed that fraud, you will need another waiver, another application to be forgiven for that fraud, which again means that you're going to be stuck in your country until you are forgiven for that fraud. If you are forgiven, you come back to the U.S. If you're not forgiven, you're not going to come back to the United States. So you need to be mindful and aware of that when you consider these type of applications. But in many cases, Yamilet, most applicants that we represent did not smuggle anyone into the U.S. They were young and they were obviously not involved in any kind of alien smuggling of any family members. In most cases, our clients were not involved in any fraudulent activity in seeking a U.S. visa to come to the United States. In most cases, our clients were not detained at the border and given what we call an expedited removal order. Most people don't have these issues. And so I think it's important, again, to differentiate between individuals who are going to have problems potentially at the interview and those individuals who are not going to experience these issues when they go to the interview. And so if you have a case where these issues do not apply to you, and there are other issues that we also have to consider during an interview, then I believe that it is important for you to move forward with your application because it is much more risky to stay in this country illegally, not knowing what may happen in the future with your unlawful status.
Thank you, Carlos. And for individuals who have already started their waiver process, right, before this Biden announcement came out, they filed their waiver, it's been approved, we're just waiting for an interview at their home country. And it just so happens that they likely will qualify for President Biden's program. What would your recommendation be for them, considering
Sure. I would tell them to look at their pocketbook first and foremost, because obviously if you have already paid for that I-601A process and you have now waited years to come to that point, and you're simply awaiting the interview in your home country, it may be best, given that investment, if you are certain that you are not inadmissible for some of these reasons I've outlined, it may be best for you, given your financial situation, to wait for the interview and simply go to the interview in your home country. But I will tell you that most people would rather have the interview inside the United States, even if their cases have been granted, even if their waivers have been issued, even if they're about to receive the interview in Mexico or El Salvador or Guatemala or wherever they need to go back to. But it's I think, a personal decision that needs to be made involving their finances, obviously, because it's going to be expensive in some cases to start that parole in place process. Remember, it's not just a parole in place. After you're issued the parole in place, then you have to file the application for adjustment of status, which is the second step. For some people, that's going to be the right choice, to stop their process, to not go abroad, and to simply have the interview in the U.S. But I will tell clients that if We did the case. And they have cleared all of our obstacles, which I think are the most strict obstacles when compared to many other places, that you can feel very safe in going to the interview to pick up that legal residence for which you have already been approved. But it's a choice that I would let the client make. All that I can tell the client is that if we did that case and the waiver has been granted, you can leave the country. But if you're not comfortable with your lawyer, if you feel that the representation you receive hasn't been the best, there's been a lack of communication, lack of attention to detail. You have to remember that waiver, that pardon, when you leave the country, is not an absolute waiver. It's a provisional waiver. And so if you have a lawyer who did your case and somehow the waiver was granted for unlawful presence, but then you leave the country and you go to that interview and the consulate officer at the interview discovers an error on the part of your lawyer or finds something in your past that makes you inadmissible, then you could be stuck outside of the country, because the ultimate word, obviously, is going to be had by the consulate officer at that interview. And so it's very difficult to give that advice to move forward with that waiver, obviously knowing that the officer in your home country is going to have the last say, the final word on whether you're coming back or not. So we can certainly speak for our waivers and our work and our clients moving abroad, but I certainly can't speak to the work that was done by other offices, because I have seen cases where waivers have been granted with the assistance of other lawyers, and some of them are very good, where the individual leaves the country and then is unable to return because something was discovered at the interview, something that should have been talked about from the very beginning of the case. So you have to exercise a great deal of caution. You have to feel very confident in the legal representation that you're receiving in that kind of situation.
Thank you, Carlos. And for both of these processes, is work permit something that is issued? Is it only for one of them? Could you walk us through that?
Sure. So when you do consular processing, when you're required to apply for forgiveness and go to your country for the interview, you are not entitled to employment authorization. When you file an application that is going to lead to the interview in your native country, you're not going to get a work permit under that process. There is no work permit associated with an I-130 family petition. So that's not an option. But when the interview takes place inside the U.S., you are granted employment authorization until your application for legal residence is decided. And so certainly there's a great benefit in qualifying for your interview in the U.S., because if you do qualify, you're going to receive employment authorization to await a decision on your case. The great thing right now about work permits is that once issued, that work permit in most cases is valid for 5 years. It used to be 2 years. In other categories, it was 1 year. Right now, you're looking at a 5-year employment authorization document once issued if you qualify for the interview inside the United States.
Now, that would be the length of time that it would be granted for. But how long are these work permits taking? I've heard that a lot of them are taking a significant amount of time. Some of them are getting issued within the week. Could you give us a little more information on that?
Absolutely. And that's a great question, because many work permits are being issued within a matter of weeks, at least the new ones right now in certain categories. Other work permits, unfortunately, as you know, sometimes are taking well over a year to be issued. And clients always ask, why did this person receive a work permit in a couple of weeks? And why is my application still pending after 1 year? And there really is no answer to that question. But there are some things that the government, immigration, has done to, in essence, address that issue. Immigration understands and accepts that there is a significant backlog for certain applications for employment authorization. They haven't told us and will never tell us why some work permits in the same category are being granted in a few weeks or months, and why others in that same category with the very same facts are taking well over a year, sometimes even 18 months. They're not going to tell us that. But what they have done to address the issue is issue a memorandum. And this is important. And this goes to everyone with a pending application for a work permit, and also for employers who might be concerned about hiring someone or continuing to hire someone who doesn't have a valid work permit. The memo that was issued by immigration says that if your work permit is expired and you have requested that renewal, and you can prove that you have requested renewal of your employment authorization and you haven't yet received that employment authorization card, not the new one anyway, that the expired work permit in certain categories, I would say just about every category, not all, but most categories, is going to be valid for an additional 540 days. So let's think about that. Basically 18 months. That if the work permit expired in June of 2023, with that memorandum issued by immigration, that work permit expires June 2023 is going to be valid until December of 2024. And so what we have done in many cases is we have given the client, of course, a copy of that memo issued by immigration that says that the expired work permit is valid for 18 months. And so it's important to know that if your work permit is expired, now we're getting some feedback, but the work permit is expired, that you ask your lawyer for that memo that you then can provide to your employer that says that your expired work permit is valid for an additional 18 months. If your lawyer doesn't have it, then you can go on the USCIS website and obtain that memo from the website as well that clearly says in a very short and precise way that because of their backlog, because of what's happened since COVID, your expired work permit remains valid and it's valid for an additional 18 months.
And if I'm not mistaken, some of these receipts are coming in with that language contained therein, correct?
That's true. So some of the new receipts have that language, but unfortunately, some of the old receipts, right, from a year ago or 15 months ago, don't have that information. And so I think it's important to educate the employer. The employer wants to make sure that he or she is not going to be fined by immigration for unlawful hiring practices. And so they're always concerned about an audit, especially if it's a large company. But as an employer, all you need to show is that you're complying with the law. The I-9 requirements, most employers know, are very simple to meet and satisfy. As long as you show during an audit that the person had an expired work permit, you have a receipt showing he requested the extension, and the memorandum that says that that work permit in that category is valid for 18 months, there is no way that the employer is going to be fined or sanctioned or somehow have to deal with immigration authorities in addressing the employment of that individual. I would be happy to help that employer. That would be a very simple call in any situation with any immigration officer, because their bosses at CIS have said that that expired work permit remains valid for another 18 months. That's the end of that conversation. Very simple.
Thank you, Mr. Cruz. Now, I just want to circle back to our first topic on the current status of the parole in place announcement from President Biden. Do you have any recommendations, warnings for clients who are looking to hire for that kind of process right now?
Number one, you should not hire a lawyer yet because that process is not yet in effect. The regulations have not been published. We don't have exactly the form. We have a real clear understanding of what the form is going to be. It's going to be the I-131 application, but they haven't told us that yet. They haven't given us the fees. They haven't issued the requirements. I mean, we could speculate about what they're going to ask for and what forms we're going to use and how we're going to submit these packages, but it hasn't been issued yet. So you can hire a lawyer until you know that the program is now in effect. But what you can do is prepare for what's coming. And mainly, you're going to need your birth certificate. You're going to need your marriage certificate to that U.S. citizen spouse. And those are easy documents to obtain. But more importantly, I think, is begin to gather your evidence of your physical presence in the U.S. for the last 10 years. You have to prove that you lived in the U.S. in essence from June of 2014 to June of 2024. So what I advise clients to do is to go and buy 10 manila folders and label these folders 2014, 2015, 2016, all the way to the present, and include your evidence in each one of these folders. Question is, what kind of evidence should I use? Well, mainly paycheck stubs, bank account statements, any receipts, credit card statements, any bills, even your kids' school records may help. Taxes are certainly beneficial. Vaccination records are obviously also helpful. And the more you have, the better. You don't have to prove every day for the last 10 years, but I think you got to use your common sense. And so at least a document for every couple of months would be important to provide. Remember, the more you document, right, that application, the easier the case is going to be. If you have to rely on letters, that's going to be more difficult. If you have to rely on just a document per year, that's going to be challenging. You have to remember that the officer's looking at this case and comparing it to many other cases. So if your case looks well prepared, well put together, then that office is going to feel very confident approving that case quickly. If the case obviously doesn't look well prepared, well put together, it doesn't have enough evidence, or it's not a significant document or set of documents, then that office is going to be a little more reluctant to apply the case. And what you want to do is you want to make their job easy. If you make their job easy, you're going to get a very easy response, a very quick solution, right, to that application. If your case has to go to secondary review, or you have to get a request for evidence because the documents are missing or lacking, that's going to delay the approval of the application and the issuance of that parole in place, the issuance of that work permit. So you want to make sure that you have as many documents as possible to document the last 10 years in the United States.
Well, thank you, Mr. Cruz, for your explanation. I think that's all the questions that I have for today's segment. If there's anything else you'd like to communicate to our viewers.
No, please. Thank you thank you for tuning in. Thank you, Yamile, for asking me these great questions. Thank you.